Now that you've finished your Utah law segments of your required 120 hours, it's time to talk a little bit about a key concept review. In this review, we're going to look at some of the things you need to know for dang sure in order to pass the exam the first time, but also key concepts that are important to your practice of real estate. Remember, you are issued a state license by the state of Utah to sell real estate anywhere in the state of Utah. But with that state license comes responsibilities to abide the law. So it's important that you know these concepts. Let's start with the discussion of the real estate division. The real estate division is there to administer your license. They're the people that are full-time state employees that are there to serve the public, which of course includes you. But as you receive your real estate license, understand the responsibilities that goes with that. And that is to obey the state laws and the rules and regulations of the real estate division. The real estate division includes the staff that I've been discussing and also the real estate commission. Together, they work with administering all the rules and the laws as it applies to your real estate license. So, there is a director of the real estate division who is a full-time state employee and can have no conflicts of interest. They work under the supervision of the director of the Department of Commerce, but they are appointed and serve at the pleasure of the governor. They're responsible for preparing the budget and for hiring and firing people at work in the real estate division, such as secretaries and others that are all full-time government employees of the real estate division. Working with the real estate division is also the real estate commission. The real estate commission members are appointed by the governor and approved by the state senate. There are 5 commissioners total, 4 of which have a real estate license or background, and 1 which is called the commissioner at large, which cannot have a current real estate license. We call this 5th commissioner the commissioner at large, and the commissioner at large must be a member of the general public. In the past, the commissioner at large many times has been someone from an affiliated industry like a mortgage broker or perhaps someone that works at a title company. Many times they've been lawyers as well. But that comprises the real estate commission. The real estate commission serves 4-year staggered terms, and they cannot serve 2 consecutive terms back to back. However, they can serve a 4-year term and then be absent for a while and then come back on the commission later. They must come from 5 different counties. Usually there's always one from Salt Lake County, usually Utah County, sometimes Weber County, and sometimes Summit County, which doesn't leave a whole lot of slots available for other counties in the state. Many times we have commissioners from Carbon County and quite often from Washington County, but each member of the commission must come from a different county in the state of Utah. If there's 5 of them, 3 constitute a quorum. They select their own chairman, which usually is the person that's been there the longest, but not necessarily. And that person chairs all the meetings of the commission. This is not a state employee type job, but they are paid a per diem for their expenses while they're on real estate commission business. They have a responsibility for updating and prescribing the content of the exam. They also create standards of conduct for real estate licensees and also for individuals involved with property management. They create rules for the proper handling of funds and record keeping. They also decide what has to be in the pre-licensing curriculum that you're taking to become a real estate licensee. And they also have the authority to decide what topics would be appropriate for CE credit even after you have your license when you get CE credit for renewing of your license. And they advise the real estate director on other matters that affect the real estate industry as a whole. Okay, it's important to know that the commission create and regulate rules, not laws. The legislature creates the laws, but the commission makes the rules. The laws set down by the state legislature are kind of like the broad strokes. They're the things that must happen, like you must be a certain age, you have to have a certain number of hours. What comprises those 120 hours is pretty much up to the real estate commission. So they do the fine tuning of it. But the commission enforce the rules And the courts enforce the laws. The commission makes the rules, but the legislator makes the laws. And that's an important distinction you need to know. I think you have a good idea and flavor after watching and listening to the course that you understand why you need to get a real estate license. For example, you need to get a license to sell or purchase real estate for someone else when you're expecting to receive a commission or valuable consideration for that service. Negotiating rents, collecting rents, writing and presenting contracts, those types of things are things and activities when you're getting paid for these things and activities that require a real estate license. But many times it's also important for the exam to understand what the exemptions are. There are real estate activities you can participate in and not need a real estate license. For example, when you're acting on your own behalf, you can certainly sell your own property. You can certainly buy property on your own. And you can certainly manage your rentals if you want to, and you do not need a license if it's your own property. If in isolated situations you're acting under the authority of a power of attorney, for example, your spouse is out of town and important real estate documents need to be signed, whether it's a contract or other type documents that require a signature, but your spouse is out of town, but you have their power of attorney. If you do that, do you need a license? Because you're signing something for someone else, but because you have a power of attorney, it's okay to do that. In fact, you don't even have to be married. You could stand in for your brother or your mother or someone else who couldn't be there to sign documents at a particular time, but yet you had their power of attorney. You are an attorney, and it's in connection with your law practice. You're a trustee under a trustee. In other words, you're foreclosing usually on a property. You don't need a license to do that, or at least not a real estate license. Or you're officers or regular employees of a utility company, like the gas company or the electric company. Often gas and electric companies deal in real estate issues, whether they are negotiating easements or they own a lot of real estate as well, and they're selling and buying real estate and whatnot. But they are not the utility company. They work for the utility company. Well, that's okay. You can do that because it is specifically exempted under the law. So that's a general flavor of the exemptions. Have a good feel for that. Let's talk a little bit about property management. Property management is obviously taking care of someone else's rentals. And there are exemptions to needing a real estate license to do this activity as well. We went through them in the course in detail, but let me summarize real quickly. Obviously, if you're the owner of the property, you don't need a license. If you're an employee, meaning that you are a W-2 salaried employee and not paid a commission, you could work for your boss. For example, you're the office administrator for a prominent orthodontist here in town. Orthodontist loves real estate, has 9 or 10 rentals, and is always looking for more. Could he have his office manager who runs the dental clinic also manage his real estate? And the answer is yes. But that person can't manage real estate for all the dentists in the building, only the one that she's actually employed by. If you're an apartment manager and you live on site, you can manage that property in exchange for maybe a tiny bit of pay and maybe some free rent as well. But you're only managing the units on site. You can't manage units in South Jordan and also units in downtown Salt Lake on 2 different sites. Only the one site that you're living in. You're working for a homeowners association. Homeowners associations often hire full-time or part-time managers to run the affairs of the homeowners association, which is a whole lot like running or managing real estate activities. Well, that's specifically exempted if you're a salaried employee. Or you provide support services, rent collecting, arranging for repairs, showing apartments that are vacant where you do not negotiate the amount of rent. In other words, this is apartment 103 and it rents for $695 a month, and that's it. You're reading it off a schedule, and if a potential tenant says, well, would they take $500? Well, then they need to talk to a licensee. But if you're just quoting a pre-established rent off of a schedule, people that show apartment buildings most of the time are not licensed agents. They're just hired by the apartment owners or perhaps a homeowner association or other entity, and they are usually not licensed. Another aspect of property management you need to be aware of is because you have a real estate license, you are allowed to sell real estate and manage real estate. But that management of real estate has to fall under your broker's flag or your broker's banner. All real estate activity must be through your broker. Of course, an exemption of that would be if you own the property yourself. But if you are managing property for someone else and you don't own it, it must be through your broker. If your broker has a general real estate office, you are allowed to do sales and management. If your broker has a management office only, and your license is under the management office, you are restricted from sales. You can only do property management. Pretty easy to tell if you're working for XYZ Realty and they do both sales and management, you're good to go in either category. But if you're working for XYZ Rental Management, then you're restricted from sales. And I know that's a little strange, but you think, well, I have a license, why can't I do both? Well, it depends on where your license is hanging. If it's hanging with a rental-only company, you're restricted to rental. But if it's a sales and rental company, then you can do both. Many brokers have decided as part of their business plan that they're going to have multiple offices, and they all have the same name. Maybe it's Hot Dog Realtors, West Side, Hot Dogs Realtors, East Side, Sugar House Office, whatever it might be. But they all have the same name except that maybe they identify where their office is located, but they're flying under the same banner. Each one of these branch offices must have a branch manager designated to run that office. The branch broker or branch manager must have an associate broker's license. And the branch broker is responsible for the activities in that office, in addition to the principal broker being responsible for the activities in all offices. Records for all these branch offices may be kept at one central location or may be kept at each branch location. The division would rather you kept it at the central office or the main office so that you're easier to audit. But whatever your broker chooses to do, the division must know where all the records are kept at all times. You must have a basic familiarization of what it takes to get a license in Utah, and usually that's not a problem for most test applicants because you reviewed those before you went to real estate school. What does come up occasionally is the point system that fulfills the experience requirement for getting a broker's license. To get a broker's license, you must have 3 years full-time experience. That doesn't mean that you've had a license and it's been hanging with the broker somewhere and it's been 3 years and so, wow, it's month 37, I can go down and now get my real estate broker's license. No, you have to have sufficient points in order to get the broker's license to satisfy the 3 years experience. Yes, you have to have 3 years full-time experience. But what does that mean? Well, the division, through the commissioners, have come up with the point system. And so there's different points you can get for different things. Selling real estate would be the main thing they're looking for, and you get 2.5 points for every piece of residential real estate that you sell, more for duplexes and fourplexes, more for apartment buildings, a couple of points for an improved lot, 10 points for vacant subdivision land. Just have a basic familiarization. Also have a basic familiarization on optional experience. In other words, you could perhaps have 2 years full-time experience as a real estate agent and 1 year's experience as perhaps a CPA or a mortgage loan officer or maybe a licensed escrow officer or maybe a designated appraiser or a general contractor or a bank officer that does real estate loans and so forth. Even being a licensed pre-licensing instructor can get you some points towards your broker experience. But whether it's actual real estate experience or alternative experience that they will accept, it still has to total 3 years full-time experience. Not 2 years plus something else, but 3 years full-time experience. That is the key here. Part of that 3 years full-time experience can be fulfilled by other types of acceptable activity, but it's still 3 years of experience. That's what I want you to remember. Can you get a Utah real estate license, whether it's a salesman or broker's license, and be a non-resident? Yes, you can. There's not a problem with that. the requirements are pretty much the same as they are for getting a license if you were living here. But there is one exception, and that is if you are a actively engaged real estate licensee in another state and you're in good standing, then they may waive part of your experience requirements. They may even waive part of your educational requirements on a case-by-case basis, particularly if the state you're currently licensed in uses the same national portion of the test that we use here in Utah. And that is done by a national provider. If you've passed it once in your home state of, let's say, Idaho, they may waive you taking the national portion. You may only have to take the state. And that's reviewed on a case-by-case basis depending on which state you're from. And, of course, everything is predicated on you being in good standing in your resident state. But you can get a non-resident license. If you're getting a non-resident broker's license, you must maintain a trust account in the state of Utah. And you must also have a physical address in Utah where your records are kept. Not a Dropbox place, but a place where your records are actually kept. And usually you can find someone that will accommodate you and keep a couple filing cabinets in your basement or something. But getting a non-resident license in Utah is certainly something that can be done. There are a few states in which Utah maintains something called reciprocity. Now, what that means is if you're in one of these favored states, and there's not too many of them, but if you are in one of these favored states, they will issue you a license in Utah without any further bother other than a small application fee. And that's pretty cool, but there's not that many states that do that. You have to check with the division to find out if you have a license in one of these favored states, and if so, you're pretty much good to go in Utah with just an application fee and a little bit of a background check. So that might be something you'd want to check. And that comes and goes with various states. At one time, we had reciprocity with the state of Montana, and I obtained a Montana license for only a $50 fee in the state of Montana because Utah would allow Montana brokers to do the same thing in the state of Utah. But after a while, I guess there was a falling out between the states, or that changed, or maybe no one ever asked for it. So they don't do that anymore with Montana, but yet they might do it if you ask. So it's something that changes a lot, and you just have to check to see which states are in that favored reciprocity status. And sometimes if it's not in that status, it doesn't mean it couldn't be there. It just means that something has to be worked out between the real estate directors in both states and then approved by their commissioners, and then away you go. Might save you a bit of schooling, but at this point, if you're listening to this review, you probably already had the schooling. So let's keep moving along here. When you receive your license from the state of Utah, it's going to have two pieces to it. There's a large piece, which we affectionately call the wall license, and there's a small piece that's a pocket card. You're supposed to carry that pocket card with you whenever you're conducting real estate transactions. And it's just good to put it in your wallet or purse and keep it there all the time. The wall license must be given to your principal broker. And even though we call it a wall license, it doesn't have to be hung on the wall. It just needs to be kept in a file somewhere so that if someone from the general public, if they happen to come into the office, could ask your principal broker or staff, hey, that Rick Roller guy, does he really have a license? I want to see it. And they'd have to produce it to show that, yes, he really does have a license. When you transfer from one broker to another, you have the right to get that wall license back so that you can go to your new broker and then give that wall license to them. But of course, a lot of this is done electronically now, and you can either change your affiliation with a physical card, or you can request this online and then have brokers email back and forth with the division and then accomplish it that way. But you still need to go get that wall license because you have to give that wall license to your new broker. You understand that you are going to have to renew your licenses every 2 years. And this has nothing to do with your birth month or anything like that. It's the month in which you were first licensed that they go from. So what happens, every 2 years you have to go into the division and renew that license. At the time you renew, you have to pay your renewal fee to the division, and of course you have to have attended your CE credit classes. The CE credit classes currently required by the division are 18 hours. 9 of which must be core credit, and the other 9 could be core credit or it could be elective credit, either one. So you could have 18 hours of all core, that'd be fine. But you have to have a minimum at least 9 core and 9 additional credits, which could either be elective or core, your choice. But you have to have that done. Now, please listen. You need to get this done prior to the last day of the month in which your license expires. Please do not wait till the last minute in order to get all your CE credit, because the way this works in our state is all CE credit is credit banked. Anyone that's providing CE credit classes must be licensed by the state of Utah, and these classes have to be approved by the real estate division. So they have to be taught by an approved instructor, and they have to be taught with a approved curriculum, and each one of these classes has their own individual identifying certification number. Look for that, and so they will tell you this is 4 credit hours of core, or this is 4 credit hours of elective classes, whichever it might be. The credit provider, after you've completed the course, is required to credit bank that with the service that the division uses to administer their CE credit program. This is a company based somewhere back east. What happens is your provider then credit banks with them. They then take this report, compile it, and then send it back to the state of Utah. It takes a few days to accomplish this. The division says that you must have all your CE credit done by no later than the 15th of the month in which you must renew. And so if you wait till the last day or so of the month, you may very well take your classes, but they won't be appropriately credit banked into the division's computer until a few days into the next month, which means that you have to renew your license prior to it expiring at the end of the month. Well, okay, what's this all boil down to? You're going to be charged right now a $50 late fee if you renew your license on the 4th or 5th when your credit banking finally comes through. You don't want to pay that penalty, plus the fact that you can't sell real estate for 4 or 5 days while you don't have a renewed license. So just be aware of these things and get your credits early. Don't wait to the last minute. And I know that no matter how hard I preach this, you're probably, there's 1 or 2 of you out there that are going to wait to the last minute, and it just creates a lot of turmoil and a lot of headache. You may choose to go inactive for a while. If you choose to go inactive, then you just notify your broker that you're leaving, and you can do this by email, or probably it'd be best to go talk to them. And then you put your license inactive, and if your license is inactive, you can't do anything in real estate. Yes, you have a license, but it's inactive, so you can't do anything with it. So what happens is, as long as you're inactive, you have the privilege of paying your renewal fee. The only advantage of being inactive is the fact that, number one, you probably don't have MLS dues if you are in a jurisdiction where you're participating in the MLS in maybe a local, state, and national association of realtors board. So that might be one advantage. But the other advantage is that sometimes we have a number of our brokers and agents that leave the country for a while. They go on a mission for their church, or perhaps they go do compassionate service, or perhaps they're called up in the guard unit and they're off doing other types of service for your country. And there just aren't a lot of CE classes in Kuwait. There's not a lot of CE classes in the desert somewhere. So what happens is you could take stuff online, it's true, but if you are inactive, all you have to do is pay your renewal fee. And if you pay the renewal fee, then you don't have to have your CE credit done. Now, when you go to reactivate, you've got to catch up on all that credit. And this is something you're going to have to talk to the division about on a case-by-case basis, because if you've been inactive for a number of years, they're going to require you to not take just any old CE credit course. They want you to take some Utah law course and other courses that would get you ready to get engaged in the business again. And those courses are sometimes referred to as recertification courses, but they're just CE credit courses for the most part that involve Utah law and current rules and regulations so that about the changes that have happened in real estate since you've been inactive. Makes a lot of sense. But the division will look at your length of inactivity and they'll tell you what you need to do to renew. And of course, if you have some credit banked already, you'll get credit for that. But just reactivating after a number of years, you just can't go and take a bunch of elective credit. It's got to be specific things, and you get your guidance on exactly what you have to take from the real estate division. What if you don't pay your renewal fee? Well, if you don't pay your renewal fee and it's been 6 months since you should have paid it, then you're going to have to start all over again. Your license will have lapsed at that point, and you're going to have to take all 120 hours again, including passing that wonderful test with the required 70% C- on the multiple choice test. So you're going to have to do all that. So just keep paying your fees, and you won't have to take that test again. And if you do want to become active again, get with the division, and it'll tell you precisely what you need to do in order to get that license reactivated. You understand that the division has what they call reporting requirements. In other words, they need to know where you are. If you have physically moved to a new location, they need to have your physical address, and they want this information within 10 days. If you change your name because you got married or got divorced, or you just decided to change your name, whatever the case may be, you have to let the division know within 10 days. Also, if you've been convicted of any criminal offense, you have to let the division know. Now, if you filed a personal bankruptcy and you're a broker, you have to let them know. Be aware that if there are changes that are happening in your life, there's a 10-day notification period required by the division. They're pretty rigid on this. If you're a day or so late, you don't want to do that. But if you're 6 or 8 months late, you really don't want to do that. Just keep in mind that if you change your address, if something changes in your life as far as convictions go, if you change your name, the division needs to know. It's very important. And one other thing, from a practical note, the division many times will try to get in touch with you by email. Perhaps that's how you're going to get your newsletter from the division, or perhaps that's how they might notify you of a license expiration that's coming up, that sort of thing. So you need to have a good, solid, current email address. I would heartily recommend to you that you do not use your company email address. For example, rick@hotdogrealtors.com, unless you own Hot Dog Realtors, but don't do that, because you might change your affiliation, go for a different brokerage firm, and forget to tell the division. Not that that is one of the required things, but it's one of the things that they're not going to be able to get a hold of you if they don't have the right email. So use a personal email that belongs to you. Don't use one that, this belongs to someone else that might change. Maybe your brokerage picks up a franchise and they change everyone's email and you forget to let the division know. Use one that you control, that you have. That's a practical note, and it's not on the test, but it's something that could affect you if the division's trying to get a hold of you by email and they can't get a hold of you. There's a lot of information you studied on violation of rules, and a rule starts with the letter R. So it might be R162-6-1. It might be R162-6-1. Well, that's a rule that the commissioners have put into place, something that you're supposed to abide by. And they also have standards of practice that go with those. All of these rules and standards of practices can be viewed and perused at the division's website. This is the definitive source of all the rules and regulations that govern your activity. If you're looking at an old printed set of rules that are 2 or 3 years old, occasionally rules change or they get redefined. And as that happens, the division is meticulous in making sure that the website is updated. It is a definitive source. So if you're looking for changes, they have a category usually called changes in rules. But if a rule was changed a couple of years ago, you might want to go to the actual section and read that rule so that you're really truly informed. I would suggest that if you have nothing to do, that you sit down and you read all the rules, because we covered everything in class, but a lot of times they're just important to know if you're crossing a line or not. And the definitive source, once again, is the division's website. There's a lot of definitional things you're going to have to know, and there's about 400 terms that you really don't use that much in common language that are important for you passing the real estate exam and important for you having a basic founding, your feet on the ground so you're not going to get in trouble in real estate as well. False devices, for example, is not a term you use a lot out there in the real world, but false devices are anything that's not true. False tax returns, false bank statements, anything like that. But there's a list of these things. Make sure that you have a good handle on the vocabulary under Utah law. Okay, someone's really nice and they give you a lead. Maybe it's a neighbor of yours who has a brother who wants to sell a house. You go talk to the brother, and sure enough, they list the house with you. Wonderful. You want to reward your neighbor, your friend, for giving you that referral. Can you give them something? Sure. Thank you card might be appropriate, a hearty handshake, and maybe just a sincere thank you might be appropriate enough. But you've decided you want to go beyond that and give them a monetary reward as well. Your neighbor does not have a real estate license. Can you give them a gift basket or maybe Cineplex movie tickets and dinner or things like that? You can if it is for a non-solicited referral. Now, let's clarify this. We're always telling people, I'd love a referral, so hey, you're soliciting referrals all the time. That's not what the division means. What they mean is that you've entered into some sort of a bird dog or finder's fee arrangement with this person where you say, hey, every time you give me a lead, I'll give you some money. Cannot do that. Any amount of money. Cannot do that. You can give them an unsolicited gift for an unsolicited referral. Now, wait a minute. You're really parting, things really skinny that way. Well, how much gift is defined by the division, and it's not that much. You certainly can't give them $2,000 or $3,000 of your commission unless they have a real estate license, and that license would have to be active, and that referral fee would have to be given to their broker, assuming that they're not one. Can you give gifts? You can give gifts, but keep the monetary value down under the limit prescribed by the division, and also it has to be for an unsolicited referral. To give you an example, I was in Phoenix not too long ago, and I ran across a flyer from a real estate agent that said, steak or lobster, you choose, send me a referral, and I'll send you out to dinner somewhere. Well, that is an excellent example of soliciting a referral. You're offering a monetary reward for a referral. You cannot do that. You're telling people you would love to help other people. That's fine, but if you offer a monetary reward for that referral, that's a solicited referral, bird dog or finder's fee, and in any amount, that is not going to work for you. If someone's going to find out about it, tell the division, and if they can produce a document or something that shows that you were soliciting referrals and offering monetary gifts of whatever value, it's going to get you in trouble. Your license allows you to fill out pre-approved forms, as well as some other forms as well. There are only a number of pre-approved forms, and the number isn't really that high from the Utah Division of Real Estate. You're going to be using a lot of contracts that are not approved by the division, and that's fine too. But the contracts have to be either drafted by an attorney for your firm's use, or they have to be sold or provided by a firm whose business it is to provide those types of forms, like the Utah Association of Realtors. Many of the forms that we use are not state approved, but they've been written and approved by the Utah Association of Realtors, and whether you're a member or not, you can use those forms. You can get them from the Utah Association of Realtors website. Your broker probably has a lot of those forms as well. If you're a member of the Multiple Listing Service, you can get them there as well. But your license is what allows you to fill out these forms, and quite frankly, that's a limited practice of law, and it needs to be well thought out. Your course here at Pareto Schools has been real exacting and definitive in telling you that if you're going to be customizing paragraph upon paragraph of customized verbiage to express how an individual contract needs to go together, that needs to be done by an attorney. There are supplemental clauses that you can use that have been approved by the division, and where you need to express something that fits one of those clauses, you must use that clause. But to draft contracts, it's a fine line. So be very careful. Seek the advice of your broker or your branch manager. And many times you might be talking to an attorney to custom draft addendums for you. And that's a really good thing to do. You know, attorneys are inexpensive for pre-litigation. In other words, if you get an attorney to draft something for you, it may only be a couple $100 or less. Many times your broker may have an attorney on retainer, and it doesn't cost you anything. Where attorneys become expensive is when they have to go to trial, when they have to do depositions, where they have to do all these other things, and that's real expensive. So for pre-litigation work, you know, I've always used attorneys when you have to express something that's a little bit beyond something that a real estate agent or broker should be drafting. The rules and regulations of the real estate division require real estate licensees to give a copy bearing signatures of all contracts signed by the general public. So whether they're a buyer or a seller and they've signed a contract, they have a right to receive a copy of that contract bearing all the signatures. So you're going to be getting these contracts and maybe transmitting them electronically or transmitting them physically, but they have a right to have a copy of the contract, not a blank one, but one that's filled out and one that has all signatures on it, both theirs, if they're the buyer, and the seller's, or vice versa. They have a right to that. In fact, this is such a stickler with the division that we as practitioners require usually the buyer or seller to sign a receipt that we can prove that we gave them a copy of the contract bearing all signatures. And most brokers require you to get that receipt signed and have that in a file, or you're not going to get your commission check. So make sure that everyone gets a copy of all the documents signed and that you have a receipt showing that all the documents have been delivered as well. Okay, a moment ago I was talking about unsolicited referrals and the fact that you can give a monetary gift of a small amount for that unsolicited referral. But you can give gifts or inducements for business to anyone you're doing business with. Now, wait a minute. That's a contradiction. No, it's not. A gift or inducement is given to either a buyer or a seller, people that are a party to the transaction. The unsolicited gift rule is given to someone who referred that person to you. So a gift or inducement is saying, hey, list your home with me and I'll give you this great vacation to Las Vegas, which you paid $500 for or something. That's okay. You can give a gift or inducement in any amount to a party in the transaction, and that's going to be a buyer or a seller. So buy a home through me and I'll buy you a washer and dryer, or list a home with me and I'll give you this great gift when it closes. There's lots of ways to do the real estate business, and some brokers are actually out doing rebating. And now, if you're going to be doing rebating with buyers, where if they buy a house of a certain price category, they get a piece of your commission back, there's no problem with the division from that because that's a gift or inducement for business. But make sure that if that buyer is getting a loan on the property, that it's been cleared to the underwriter as well. So you don't want to be okay with the division, but then have a lender come back and say, well, wait a minute, you provided X number of dollars for this buyer, and we didn't know about that, and we consider that loan fraud. You know, it's really not loan fraud if you let them know up front and they approved it. They're okay with that, that's fine, which most of them will be. There might be a couple of cases in government loans, particularly FHAs, where they might have to get some clearance on that. But underwriting rules change with the winds, and so you're going to have to work closely with your lender partner in order to make sure that what you're doing on rebating, gifts, and inducements is all right with the underwriters. One of the things I just love about real estate is that old things become new things, and new things then become old things, and it's really interesting because back in the 80s, when I was selling real estate, we did a lot of owner-carry type financing. It's the only way we could get deals done because interest rates were over 12%. In fact, at one point, they're over 13%. So we were doing a lot of owner-carry type financing, and that's fine. But today, when interest rates are so low, there are good situations for sellers that can present themselves where they might make a little extra money, or they might be able to put together a deal because of owner financing or seller financing. And certainly nothing wrong with that. However, all loans today have what's called a due on sale clause in them. And back in the 80s, some of the loans that we were dealing with were FHA assumables where there wasn't any credit qualification. Today, all loans have a due on sale clause in them. And even though FHAs and VAs are assumable, and some conventionals may or may not be assumable, we wrap seller loans all the time in today's market, and some brokers are maybe a little uncomfortable with that, but there's certainly nothing wrong with it. However, there are some rules from the division which require you as a real estate licensee to let buyers and sellers know of the risk involved if a buyer is taking over a seller's loan unofficially. It's wise to deal with a title company that understands all the rules and regulations. And there are several title companies around the state that do a lot of seller financing type transactions. And believe you me, they have a very mean language disclosure document which let the buyer and the seller know of all the risks they might be involved in doing a transaction like that. And of course, they'll just add your name to that mean language disclosure and your brokerage name, and you're off and running to the races. But you have an affirmative responsibility, meaning you must do it, to let sellers and buyers know of the risk that they're exposing themselves to with an owner-carry type transaction where they are assuming a loan from a conventional type lender that they're not letting the lender know. And it's certainly done all the time, and you can do it, but you have to do it with everyone walking into it with full knowledge of the risks that they're taking. Personal assistants are very popular in the real estate business today. And a lot of people are building teams where people on their team may or may not have a license. What you need to know is that if your personal assistant has a real estate license, that license would be hanging with your broker as well. But then that personal assistant, because they are licensed, can do anything that you can do. I mean, they have a real estate license just like you do. But if your personal assistant is not real estate licensed, they're there to do administrative type work, they are restricted in what they can do. They can be at an open house with you, a licensee, no problem. They cannot be at an open house without you. They can deliver documents around town. They can't explain documents, but they can certainly deliver a document across town that has a little Post-it note arrow on it saying sign right here, and hand it to a person, have them sign it, and then bring it back to you. Not a problem. But as far as explaining the ramifications of the document and the detail of the document, no, they can't do that. They can have keys made, they can put up signs, they can do lots of administrative things. They cannot make outgoing solicitation calls, nor can they go door knocking for you. Not with you, but for you. In other words, they can't go out and solicit business. Now, if they're talking to a friend and a friend says, so where are you working these days? And they say, well, I work for this particular real estate agent and I help them in their activities. Oh, yeah, do you have his card? Well, that's just a common courtesy. But they can't go out and solicit business with you in any shape or form. Now, can they do clerical things like print off letters and have you sign them and then put them in the mailbox? Absolutely. Can they look up ownership records? Certainly they can. Can they put stamps on postcards and send them out? Sure they can. They can do all sorts of administrative things, but they cannot do solicitation type activities which require a real estate license to conduct, like door knocking, holding open houses, calling people on the phone. They cannot do that. The other thing about personal assistants is if they have a license, then you can do commission splits or whatever you want to. Of course, everyone being paid through the principal broker. But if they do not have a license, then they must be paid on a predetermined wage, and they cannot be paid a bonus for $500 bonus on every deal that closes or anything like that that looks like you're sharing your commission. Someone feels like you've done them wrong. Well, they can file a complaint. Filing a complaint with the real estate division is easier than it ever has been. Used to be that the real estate division was buried in the blue pages in the phone book and nobody could ever find it. And so a lot of times people would call the local board, the board of realtors. Well, that's like complaining to a labor union that one of their members screwed up on delivering a package or something. They're not going to do anything. They want your dues in perpetuity, and so does the board of realtors. So what would happen is if they filed a complaint with the board, you might be brought in for an ethics type violation or something, but they're not public. And those ethics violations, if you did something wrong, you're going to get a slap on the hand and maybe a fine and maybe have to go to a class or something, but it's not a public procedure. People didn't know how to get a hold of the real estate division, but this is the age of the internet, and so everyone can just Google Utah Real Estate Division or Utah Regulatory Agency for Real Estate or whatever they want to Google. They're going to go straight to the division. And when they do that, they're going to get a person on the phone that's going to hear their complaint. This person on the phone is a member of the investigative staff. And this member of the investigative staff is going to triage that complaint. If it's something really serious, it goes right to the top. If it's something kind of minor or frivolous, it goes right to the bottom. But nevertheless, they're going to listen with patience and they're going to give their opinion to a certain degree. But they're also going to tell the resident of the state of Utah or other person that feels like they've been aggrieved that they have to send in a written complaint. And they make it pretty easy to do that because there's a form on their website they can fill out and sign and submit electronically to the division. So complaining is easier than it ever has been. Now, once they've received this complaint, they will investigate every written complaint. Whether they assign a complaint number to it or not depends on how serious it is. They might make some preliminary calls to you and say, yeah, that's kind of what we thought. Call the consumer back. If the consumer insists on pursuing it, they may then issue a number and then take it from there. But if it's a serious complaint or they want to know more, they have some things that they can do. And one of them is they can send you a copy of the complaint. They'll send one to your broker as well, listing what the complaint is. A lot of cases, it's a photocopy. And then you have the right to tell your side of the story. You must respond to any complaint received from the division within 10 days after receiving notice of that complaint. So it's very important that you abide by that time period. If you fail to respond within 10 days, it's considered an additional violation. So please respond promptly. If you need additional time to consult your attorney or to pull records together or whatever, then no problem. Call the division, talk to the investigator, and they're real people, and they will help you maybe by extending the time a little bit in order so you can be in compliance. But if you don't contact them and ask for additional time, you better stick to the 10-day limit to the money. I mean, it's very important. Once they've received your side of the story, it probably will sound a whole lot different than maybe what the consumer said. And they may then call the consumer back, ask for additional information, talk to you, ask for additional information. They may request a meeting with you to get some additional information or whatever. Sometimes they'll ask you to come down to the division. Sometimes they'll come to your office. It really depends on the nature of everything. Okay, you sent your answer back to the complaint. And the investigator reads through it and it just doesn't make sense, or it just doesn't wash, or there's something more to this. Well, then they're going to investigate a little bit more. It may be that they decide to hold a hearing. If they hold a hearing, they're going to let you know, and you have a period of time to show up for this hearing. Normally that's 30 days. If they're pulling you in for a hearing at the real estate division, it's imperative that you take your lawyer. Now, understand, if they're pulling your broker in as well, your broker is going to take the firm's attorney, and that's all well and good, and maybe that's enough. But please remember that the attorney that's employed by your broker is there to protect your broker and the firm, not necessarily you. Now, maybe they'll protect you, and that will be all you need. But on the other hand, you might want to bring your own lawyer as well. You don't want to be offered up as a sacrificial lamb just to protect your broker. But on the other hand, if you haven't done anything wrong, maybe you don't want to take your lawyer. But they didn't have to hold a hearing. Could be that they just talked to you a little bit, sent back a letter to the consumer saying their complaint is unfounded and no further action will be taken. Or it might be that you did do something a little bit technically wrong and they decided to send you a correction letter. If they send you a correction letter, that's a gift from the real estate gods. I mean, for heaven's sakes, do exactly what they ask you to do in the letter. Normally they'll say, we want you to attend a class or something so that you learn more about this, and then we want you to send us a procedural outline so that we know you've implemented steps so that this will never happen again, and we want all this done by the end of this month or next month or something. Do it. You know, I've had broker friends that have received correction letters and they ignored it, much to their peril, because they don't have to send you a correction letter. The cool thing about a correction letter is it's private. It's not on the internet. There is no formal public record in your file. It's just a simple correction letter. But if they pull you in for a hearing, it's serious. There's an old saying, it's not really paranoia if they're really after you. And so you go into the division on a hearing, I would recommend you take a lawyer. And I would recommend if you're an agent, you take a lawyer that represents you. Now, there's only a few lawyers in this state that I would take, and you're going to have to ferret around and find one that is the type of attorney that understands administrative rules, and preferably one that's actually represented agents before the real estate commission in the division previously. And that's only a handful of attorneys. Don't take your family law guy. He doesn't have a clue on what's going on up there. Take someone that knows what's going on. They're probably going to be a little bit more expensive because the rules are tricky and they have to be followed precisely, and you're going to need some representation. Okay, you went to the hearing, they found out that nothing was wrong, they agree with you, and everything's dismissed and you're fine. Or they find out that something is wrong and you did something wrong and you need to be chastened and disciplined. The commissioners are the ones that are going to decide what's going to happen to you, not the staff at the division, not the investigators, it's the commission. Remember those 5 people, 4 of which are real estate licensees, probably your competitors or friends in the business. Hey, this is a really good thing because those 4 commissioners on the 5, those people that are actually in the business. They've seen a lot of things. They've heard about a lot of things. They may have even done a few things. So, you're talking about people that are actually been out there on the streets and are making it work. This is a great thing because you're being judged by a knowledgeable quorum of your peers. Remember, 3 out of 5 is what it's going to be. So if they're going to discipline you, they could fine you, and that money goes into the real estate recovery fund. And the fines could be high. Used to be in our state, we had a limit on those fines, but they took that off a few years ago, and you can see from disciplinary sanctions at the division that some of these fines could run quite a bit of money. $10,000, $5,000, $7,000. I saw one fine was over $20,000. Fines can be extensive, depending on how severe your activities were. If you're ever curious and want to attend some of these hearings, you can do that. As a matter of fact, if you sign in and let the people at the division know you're there to attend the hearings or the commission meeting and then the hearings afterwards, you'll actually get some CE credit for it. But you'll also see how fair they are. And they are fair. But understand that there are rules and there are laws as well. And if you did some dastardly deed, you're going to be called on the carpet for it. Now, in addition to fining you, they could suspend you for a while. What can you do when you're suspended? Nothing, as far as real estate goes, as real estate licensing activity goes. I mean, you can't do anything. They could revoke you. If they revoke you, then you cannot get another license for 5 years. So, fine you, suspend you, revoke you. They could also require you to go back to real estate school or take some CE credit classes so that you're a smarter individual and won't do these heinous crimes. What they cannot do to you is put you in jail. They could recommend to the county attorney or even the AG's office that they pursue you on another type of charge, criminal charges, for example. And then, of course, when you're in front of a real judge, then you could be put in jail. Every broker in the state of Utah must maintain a trust account. The trust account is where they deposit monies that belong to other people. Do they always have to use their trust account? No, there are a couple of exceptions. One of them is if, for example, the buyer decides that they want to put their money into an interest-bearing account. Well, then they have to put it into a separate interest-bearing trust account. So it's not their normal trust account, it's a special trust account that they set up. There are some cases where brokers have in the fine print of their listing contract that they allow the money to be put into a interest-bearing trust account on a regular basis, and then the interest is harvested out of that account and then given to a housing-type charity. The one that's normally used in our state is URHOF, which is a charity that's pretty much run by the Utah Association of Realtors. So that is a possibility that they don't use their regular trust account, but they use a special interest-bearing account. It could also be a situation where the buyer or seller has requested that the money be put into, for example, a title company rather than the broker's trust account. And we're seeing more and more sellers insisting on this, particularly on REO-type properties where they want the earnest money of the buyer put into a title company's trust account. Well, that's fine. But all this has to be contractual. There has to be an addendum that states if the money is going into an interest-bearing account or if the money is going into a totally separate account that's not controlled by the broker. Years ago, I did a lot of work for a syndicator out of California, and I sold them lots and lots of properties in Colorado. And when we did larger earnest monies, like $50,000 or $60,000, and this is going back in the late 70s, he always insisted that we use a trust account at a title company, not my Rick Roller trust account. And that was fine with me. I mean, he understood that this was monies that were actually coming from his investors. He was a syndicator. And so they were limited partnership monies. As a general partner, he was tasked at making sure they were kept safe. And so although he knew me and trusted me, he also knew that trust accounts, brokerage trust accounts, really are nothing more than checking accounts that have been designated as trust accounts, but it's still my account. You know, if I'm having a bad hair day and decide that maybe running a bait shop in Belize would be a better activity for me to do than selling real estate, I could take his $50,000 and hightail it for the border. Better to put it in some state-regulated title company account where those funds are underwritten, per se, and the activities of that company are underwritten by a national title insurance company. And so there's some validity there. So in fact, many states, not all of them, but like the state of Montana, they have a provision in their law that real estate brokers don't have to have a trust account in Montana at all. You just designate which title company you want to use. So Utah's a little different in that all brokers have to have a trust account. Whether they use it or not is optional depending on the transaction. A lot of brokers some of the larger brokers in our state are requiring all earnest monies to be put into a title company trust account so they don't have to administer it. But nevertheless, they're still responsible for it, but they figure the title company, they're good for it, or at least their national underwriter is. So something to think about there. These trust accounts are highly regulated. They have to be monitored by audit. If the division decides they want to see the records, those records must be turned over immediately to the division so they can audit. And if they want to do a serious audit, they can even hire a CPA to come in at the broker's expense to try to figure out what is happening in that trust account. The account has to say real estate trust account on the account, and it has to say real estate trust account on the checks that are used and also on the deposit slips as well. And it's supposed to be a non-interest-bearing account. That's why a broker could have another account that did bear interest, but we already talked about that. It has to be in a bank in Utah, or it could be a credit union, savings loan, or other approved depository, but it must be in the state of Utah. And the principal broker can have as many trust accounts as they want, but they cannot have any secret trust accounts. The division has to know about every single trust account that's out there. What the trust account is trying to do is to prevent something called commingling. Commingling is where the broker mixes his money with monies that come in from buyers or, rare cases, perhaps sellers. When that money is mixed with the broker's money, it's called commingling, and that's a crime. That's a crime in Utah. In our state, brokers can have up to $500 of their own money in that account just to keep the account open. But anything beyond that is going to be commingling. Deposits must be made in the trust account in an appropriate manner and with expediency. Now, the state requires that all earnest monies must be deposited within 3 days of receipt of the earnest money. 3 days. However, there's a provision in that rule that says, or as otherwise agreed to between the parties. Well, the or as otherwise agreed to between the parties is in the state-approved real estate purchase contract, where you can check a box and say that you're going to have 4 days, or you can check a box and says that, well, I'm going to get the earnest money sometime in the future, and then I have 4 days after that to get the money into the trust account. So the state law still says 3 days, or as after receipt, or as otherwise agreed to between the parties. But if you're using state-approved form, which you probably will be, the or otherwise agreed to between the parties would rule because of the provision in the regulation. If you're taking earnest money in the form of a promissory note, then that note has to be kept by the broker and kept in their file. There's a long process involved with getting money out of the trust account. Obviously, the best way is, and the quickest and shortest, is to close the transaction. On the settlement sheets, the earnest money is usually credited for the buyer's benefit, but then it's also debited against the broker's commission. So what happens is the money mysteriously morphs into broker's money at that point. And so he can take the money out because he has the settlement sheets from the title company. A conventional real estate broker who has both sales and management activities in their office may use their regular trust account for their property management activities until the number of accounts that they are managing exceed 6. That would be 7. 7, or exceeding 6, would require a conventional real estate broker to have a separate property management account for their management activities. Utah does not require their brokers to be bonded. The reason why is because in Utah, we have the Real Estate Recovery Fund. The Real Estate Recovery Fund is a pool of money that when you apply for a license and when you renew your license, little bits of money are taken out of that license fee and put into the recovery fund. By law, the recovery fund must have, at the beginning of any fiscal year, a minimum of $100,000. The purpose of this fund is to reimburse the public for harm caused by dishonest licensees, and also to provide revenue for research and education in the real estate field. In addition to little bits of money that come out of your license fees that go into the recovery fund, all fines that are levied by the Real Estate Commission, those monies go into the recovery fund as well. So if it's a $500, a $5,000, a $25,000 fine, that goes in the recovery fund as well. Utah does not require their brokers to be bonded. The reason why is because in Utah, we have the Real Estate Recovery Fund. The Real Estate Recovery Fund is a pool of money that when you apply for a license and when you renew your license, little bits of money are taken out of that license fee and put into the recovery fund. By law, the recovery fund must have, at the beginning of any fiscal year, a minimum of $100,000. The purpose of this fund is to reimburse the public for harm caused by dishonest licensees, and also to provide revenue for research and education in the real estate field. If a consumer is successful in tapping the fund, the maximum amount that they can get out of the fund is $10,000. And the maximum amount the fund will pay out for any one licensee is $50,000. Okay, let's go through the numbers one more time. $100,000 is the minimum amount that must be in the fund at the beginning of each fiscal year. $10,000 is the max that any consumer can tap the fund for their aggrieved problem that they had with the agent. That, of course, only comes out by judgment and court order. And the maximum that can be paid out for any one agent is $50,000. By the way, right now on the renewal fees, $36 goes into the fund from brokers and $24 goes into the fund for agents. And that changes from time to time, but that's what it is right now. Brokers are responsible for record keeping, but agents have a responsibility in that regard as well, and it's wise if you keep your own records. The division can require records from agents. If your broker's gone out of business or moved out of the state, it might be difficult to obtain those records, so you should have your own copy of all the transactions you've ever been involved with. The records must be kept for 3 full calendar years following the year of the transaction. So, if you had a closing that occurred in, let's say, December of any one year, those records only have to be kept about 37 months, the rest of November and then 3 full calendar years. But if you have closings in the first of the year, January, February, those records are kept almost 4 full years. But it's 3 full calendar years following the year of the transaction that records must be kept. And the division can require those records from an agent or from a broker. It's primarily a broker responsibility, but please keep your own records. It's something you need to do. In regards to Utah law, there is a term called statement of account. If you have a transaction under contract, it's pending, it's an escrow, and a consumer feels that you're not keeping them apprised of what's happening with their particular transaction, they can formally request what's called a statement of account. Statement of account is a requirement that the broker now has to give a written report on what's happening with that transaction every 30 days until that contract either closes or fails. And that's called a statement of account. It's not how much money you owe Discover Card. Its statement of account is when a consumer requests a report. Now, hopefully you're keeping in touch with your buyers and sellers on a regular basis anyway, because that's the proper way to do business.